dynamic and interactive radio phoning show that gives listeners a platform to voice their opinions on current affairs, social issues, and community concerns. With engaging discussions, expert insights, real-time audience participation. Voice of the People.
This is Voice of the People right here on the Power Breakfast on 91.3. We are live on Bits TV channel 92 on Topstar, and we are also live on Power FM Zambia on our Facebook page, so you can leave a comment and be part of the conversation. This is Fortress with Patrick Chifamba, as we'll be hosting Ms. Ruth Kangwa, a human rights lawyer, and Mr. Muleta Kapatiso, who's also a lawyer, as conversation on the Constitution Amendment still continues. Education, information, and awareness campaign is what we'll be diving into, and the topic is talking about revision of the definitions of child and adult. Zambia's Constitution under Article 266 currently defines a child as any person below the age of 18, while this broadly aligns with international standards such as the UN Convention on the Rights of the Child, to which Zambia is signatory. The definition lacks the clarity and contextual detail needed for consistent legal interpretation, and that's why we're going to dive into this conversation this morning. Welcome to you, and thank you very much for joining us, Ms. Ruth and Mr. Muleta.
Very good morning to you.
Good
morning. Thank you very much for having us.
Please, first things first, can you explain what Article 66 of the Constitution currently says about the definition of a child and why it is still unclear?
So before we get right into the questions, and I hand over to Mr. Kapatiso,
sure.
I think it's important to set the context of this conversation about revising the definitions of child, adult, but as well as an interesting one that we've seen in provision number 13, which is also the revisal of youth, as this definition also has got correcting a contradiction that we've seen in terms of the implementation of policy. So the current constitution under Article 266 of the 2016 Act defines a child as anyone that has attained or is below the age of 18. On the face of it, it aligns, of course, with the UN Convention on the Rights of the Child, which Zambia is a party to and has ratified. But what we are seeing right now is that the Constitution ideally should be the anchor of laws that interpret from it. And what we've seen is a lack of coherence with the definitions, in the sense that when you then go to the definition of youth as per the Constitution now, it defines a young person as a person who's attained the age of 19 and below the age of 35.
Okay.
And when you also define what adult is, you are seeing that the age gives that is somebody who's above the age of 18. So already you have to ensure that there's a consistency with that, because what it then does is that it has a ripple effect on subsidiary legislation, which is like the Children's Code Act and any other legal frameworks that we do have in place. Yeah, so I think I'll allow my colleague to really add on.
Yeah, so our constitutional definition on who a child is in terms of Article 66 is like you have said, very unclear. And I would argue that it does not even comply in interpretational terms with Article 1 of the UN Convention on the Right of the Child. Article 1 of the UN Convention on the Right of the Child just defines a child as someone that is below the age of 18. In terms of our Constitution under Article 266, it defines a child as someone who has attained or is below. The interpretational weight of that is different from what the CRC aims to achieve. And you see this in how court proceedings occur and how the courts are sometimes struggling to reconcile which particular offender will be treated as a child within the framework of the Children's Court. Now, the background to that is that the definition of a child has evolved over a period of time. And when you look at it critically from the Liberty's perspective, from the Juveniles Act, before the Children's Court kicked in 2022 to reconcile anything else relating to the child, we had the Juveniles Act. The Juveniles Act defined a child as someone who had not attained the age of 16. Okay? That was the child, someone who had not attained the age of 16. Then there was another definition, a definition of a juvenile. And a juvenile there was someone that had not attained the age of 19. And then they even had the juvenile adult. A juvenile adult had attained the age of 19, but not attained the age of 21. There was even another secondary definition to that. So you can see all these confusion. Now, if you're going to court, you have arrested some child who has broken someone's window, and you want to determine who this particular, even right now, whether this particular person should be treated as a child. You then be asked yourself, this person says, let me use Nyanja because I don't know what the coverage of Power FM is. Let me try to use Nyanja. This person says, in nilina 18 years, nikwanisa 19 years, mu December. Okay?
Yes.
It means that person has attained the age of what? Of 18. But they still do not qualify under the definition of an adult.
Yeah.
So how do you want the court to take this particular person? They are in this floating gap, which is undefined. And some courts have had challenges, some juvenile courts have had challenges taking this particular person who has already attained in their mind. They say, oh, this person has attained 18. Therefore, they are a child to that respect, but because they are almost crawling to 19, they could be treated as an adult. Now, there are implications to the definitions. Implications are that the manner in which you treat this person at the police station is dictated by the Children's Court. The manner in which you treat this person in court is dictated by the Children's Court. You cannot interview this person in the absence of their guardian, of a child inspector. You cannot do that. So there is that particular confusion. And so that is the background to the confusion around the definition of a child. We have not been consistent with the text and tone of the CRC. And that's why this particular proposal sets some kind of clarity so that we don't have a hanging age in between. We don't have 18 years, 2 months, 18 years, 24 hours, such kind of things.
Now, the proposed constitutional amendment seeks to revise and harmonize the definitions of a child and an adult. That is with the Children's Code Act. So now, let me start with you, Ms. Kangwa. What is the difference between a child and an adult?
Okay, so I'll take it still from the context where we said the difference between a child, of course, we've often defined is that this is a person below the age of 18 years. And as alluded to earlier by Mr. Kapatso, is that this is a person we see as one still under the guidance of a parent, a guardian, and they haven't yet gotten to the stage where they can assume full responsibility. Whereas when we're talking about an adult, we are then looking at a person who then crosses over from 18 to 19. But then when we then bring this into the context of different legislations or statutes that are applied, I think that's where the critical issue is. Is that, for example, the penal code allows children under the age of 8 to be exempt from criminal responsibility, right? Because one would then say they're not yet fully developed or mature enough to understand the gravity of an offense they may have committed. And you will then see that below 8, they're exempt from that. But children now between the ages of 12 to 18 are judged based on their capacity to understand.
Sorry to cut you off short. Is there where the Juvenile Act comes in?
Not the Juvenile Act. We now have got the Children's Code Act.
Okay.
So the Juveniles Act was then overtaken by the Children's Code Act, which codified a lot of different statutes. We had very fragmented legislations. There was a Children's Code Act, we had the Legitimacy Act dealing with children that are seen as illegitimate or out of wedlock, for lack of a better term.
Yes.
And now the Children's Code Act is what has codified all those legal frameworks. And this is why you're seeing it also now having a ripple effect within the Constitution as the supreme law of our land. So in cases, for example, where you've got child marriage cases, right? Some customary norms recognize marriage under 18 as legitimate. So what then happens, muntu akakwanisa 18, right? And this is where the Constitution has realized that if we retain the definition which says a person is above or has attained 19, does that 18-year-old who gets married at 18 and 3 months, would they be considered as a child? Or would we then consider them as an adult? And those are some of the absence of constitutional clarity that we didn't have, right? Customary and statutory systems are already clashing in that sense. And how then do we enforce, for example, legal frameworks where we're banning early child marriages in that instance? So I think it's more of an issue to try ensure that there is completeness with the legal inequalities that are already present, but also applying it to the ordinary day-to-day life and scenario and cases. So Mleta gave us a very perfect one in relation to children who come in conflict with the law. But then I also then give you the angle of children who also find themselves in child marriages. So those definitions already need to see coherence and consistency.
So in a nutshell, what is provision number 13 proposing in light of what you've just explained?
So what the proposal is making under Bill 7, and it's good that we are still under consultation, is to just make it very clear. And the clarity of it is that the child is someone that is below the age of 18. Okay, so if you're below the age of 18, if one is below the age of 18, they are a child. And if one is above that particular age, then they become an adult. Now, what that will do is that it will align you all other legislation. And if you note, all the other pieces of legislation that have been passed from around 2021 now, whenever they are trying to define a child, those in relation to a child, the Marriage Act, for example, was amended to make marriages between children or involving a child void, so that they don't exist at all, they are not recognized at all. And when the definition comes in, it points to the definition that is already in the Constitution. The same thing applies to the Children's Code. The Children's Code, which is a consolidation of all matters that relate to a child, also has a definition around the child. But the definition around the child is not a standalone definition. It's pointing you the Constitution. So this particular provision is going to reconcile by automation of the law all other definitions across all boards. But it will also make it very simple. The question then would be, have you attained the age of 18? Yeah. If you have attained the age of 18, this is the category you belong to. Or are you below the age of 18? Are you 17 years, 9 months? Are you 17 years, 11 months, 24 hours? And those kind of nitty-gritties that others might argue during litigation to establish where this particular person is entitled to the privileges that the law gives a child. Or let's say the person that you have neglected is someone that has attained the age of 18. Would you still be charged with the offense of child neglect, for example? You know? So there are a lot of cross-cutting issues that involve a child. Let's say you are, as a state, neglecting the right to health or the right to education of a child. There are provisions under the Children's Code that enjoin the state and guardians to make sure that this particular right to health, right to education is enjoyed by a child. So the issue that really will be so clear There's nothing like between this, I have 24 hours remaining and stuff like that. Are you below 18? This is your position. Are you above 18? This is your position.
Mr. Kapatis, I read recently, I think just a couple of days ago, there was a particular case in court, I think High Court, where a judge had to release a child who was accused of murder, but because he did not fall under a particular age, and the statutes were clear to say, I can't convict him.
Yes, so there's and you see the entire legal fraternity is really excited to what the Supreme Court will say about that case. I mean, I've seen National Prosecution Authority posting it on their page. I've seen quite a lot of in our last group, for example, I've seen conversations around the Supreme Court coming in to actually bring this issue to finality. It's the same confusion. When you have definitions that can be taken anyhow, that are not so clear. Others who use their conscience and ask themselves, is this a child? Since they do not fall under the definition of an adult, can we still consider them a child?
Yeah.
Because if we don't consider them a child, what other definition do we give to them? So it's that particular issue, the confusion that comes to matters of litigation, criminal proceedings, matters of adoption, matters of marriage. So if we don't have a clarity in terms of this particular definition, the danger that we risk having is that the rights of children in Zambia will not be respected. They will be at the discretion of whoever it is that is interpreting what this provision is. But when it's very clear, a judge sitting anywhere in this country, at any level of our court, our hierarchy, will be so clear to know what kind of discretion, what kind of opportunity and privilege to accord a particular person, so that we don't have issues. We don't have issues of a lawyer coming in and saying, no, these particular proceedings were void because they do not follow laid down criteria. And the other side will be saying, no, this person is not a child in the first place. So there's no such argument at all. So there are those issues, and we're hoping the Supreme Court will bring that issue to finality. And with this kind of proposed amendment, if they were to go through, because of course we know that this particular constitutional process has been marred with a lot of suspicion, and even as we discussed right now, we cannot say that by us discussing this proposal we're endorsing the constitution as it is. It's a period for discussion, it's a period for conversation to see whether or not we agree with both process and content. And by content, we're not only paying particular to nitty-gritty provisions, it's the whole bundle of proposals.
Okay, you wanted to say something?
Ideally, I also just wanted to emphasize that from what Melita is saying is that every law, every policy that we do have, every statute derives its authority from the Zambian constitution. And when there's inconsistencies, the constitution ideally overrides. So what we are seeing with this proposed provision number 13 in bill number 7 is to look at how we avoid sending mixed signals to both the enforcement agencies but as well as to the public. And if we are a country who say we do respect international law and we've domesticated treaties like the Children's Rights Convention, then our constitution should ideally reflect that commitment. So, of course, what we've seen now is that while the Children's Code Act is a very progressive legal framework that protects the rights of children, its impact has already been weakened by the fact that the definitions or the provisions in there already come into conflict with what the Constitution defines as a child, an adult, and a youth. And I think I also wanted to just quickly throw in that what we're also seeing when the new Dawn government had come in, right, was also the separation of the child department under the Ministry of Youth, Sport and Art. And you saw that going to Ministry of Community and Development, right? And I think, I'm of the view rather, that has also helped them in terms of implementation of policy. Not to be able to have overlaps of who then falls under a bracket of 19 to 34, as per the now constitution. But we're now going to have, if the bill goes through, clarity in terms of the Ministry of Community Development, if they'll still have the child department, knowing that they deal with young persons below the age of 18. And if you're in the bracket or fall into the bracket of 18 to 35, ideally your youth policy, like the one that we recently revised in 2024, is one that applies to you. Government is in the process right now of also revising a legal framework for youth. So what does this then mean, right? This proviso, does it then mean that that particular legal framework will also only apply to youth who belong in the bracket of 18 to 35?
Yes.
And I think let us really bring out an important conversation that we must throw in, right? We're looking at just child and adult. But you'll see that the current constitution under Article 266, right, still leaves the provision of a definition of young person. Young person to mirror a person between the ages of 15 and below 18. So I think all of that also must have some form of clarity. So we'd want to see more citizens actually who are impacted by these definitions on a day-to-day lifestyle. If we look at the health sector, right, you've also got definitions of adolescent health, which is in the bracket of those young persons. So I think it's important for definitions to be clear, to be consistent, and this will then help us in terms of implementing policy that we do have at a national level.
All right. You can be part of the conversation. This is Voice of the People. The number is 0979-192-485 or 0955-997-997. You can send a text or you can send a voice note or you can go through to our social media platforms. That is on Facebook, Power FM Zambia. Join us in the studio. We have Miss Ruth Kangwa, who is a human rights lawyer, and Mr. Muleta Kapatiso, as we are discussing about the revision of the definitions of a child and an adult. So as we are still exploring the proposed amendments, what exactly is being proposed under this amendment and how will the definition be revised? I'm going to start with you, Mr. Muleta.
Well, like I earlier alluded to, the proposal is trying to enhance clarity in terms of interpretation. Interpretation influences decision, interpretation influences criteria, interpretation influences implementation. What is being proposed is that a child should be one that is below the age of 18, and an adult should be one that has attained the age of 18. So we can simply say in a nutshell that's what is being proposed. And the interpretational impact of this is that it will help, number one, level up the playing field and help adjudicators in our court system in particular. And I am emphasizing on the court system because it involves the right to liberty. Okay, it involves the right to liberty. If we don't harmonize these provisions, even the impact of the Children's Code Act is lowered down, it's watered down, because then judges at a certain hierarchy will be very careful in how they interpret or in how they consider what they are called a particular person and which category they place them in. But even prosecutors, as they draft their charge sheets, their information, determining who exactly is to be treated like a child, but also policymakers, Ministry of Community Development, the Show Welfare Department, they always have to come in whenever anything relating to a child is erupting, whether it's a court process, whether it's an adoption process, and such kind of things. But such kind of fluctuating definitions or definitions that have some smoke littering all over them might be very difficult to enforce and implement, because you don't know whether people accuse you of not.
Okay. You can hold that thought as we speak to somebody on the other side. Hello, it's you to the Breakfast Show. Good morning.
Good morning.
Good morning. Your names and where you're calling from?
Maponga Malego from Relay.
Please go ahead with your question or contribution.
This question goes to my my lawyers. According to what I've heard from this conversation.
Please kindly turn down your radio in the background. Please kindly turn down your radio.
All right. Are we okay now?
We're good. Please go ahead.
So, according to what I've heard so far on the show, the case was dismissed regarding a teenager that committed murder, and the case was dismissed, right? So, don't you think, counsel, that's advising teenagers to commit crime, and because that case was dismissed, they feel like they can commit murder and they will, go free? Don't you think we're promoting that as a law? Thank you.
Sorry, the question can be repeated for us.
I think the question was, don't you think that that will be promoting criminality because of the child that was recently released?
No, it wouldn't. It's like saying that if we're going to be giving a child porridge because they are a child, to make them eat porridge all their lives. Children, from a psychological perspective, have a certain level of development that is different from adults. And so the level of judgment is very different. And that's why even the age of criminal liability, in terms of outrightly criminal liability, excuses the children of a particular age, because you know that at this particular age they are unable to make proper judgment on what they are doing. But even in court proceedings, you find that when you have a child witness, the process of obtaining evidence or adducing evidence obtained from a child witness is different, because their level of understanding the truth, the weight of the truth, and their level of recollection of facts is very, very, very different. Also, one of the reasons why, and this is not just criminal proceedings, this delicate treatment to children, one of the reasons why, for example, we are now voiding in this country marriages involving children is because we recognize that the power of choice is not as strong in adults as it is in children. So how do you protect these particular people who may not have, for you to have to commit a crime, you need both the mens rea, the mental intention, calculated moves, and actus reus, which is the actual action of committing the crime. What we are recognizing is that the full growth and capacity of the mens rea for a child is reduced, is diminished by virtue of their psychological growth and the level at which they are. So we're not promoting them to commit crime. Of course, there are people that might actually go and recruit children in order for them to commit, but those are the ones that would be punished and not the child per se, because of the level of their brain formation and their capacity to make independent decisions.
You're through the voice of the people. Good morning. Good morning. You're through the voice of the people.
This is Nsaka from Kanyama.
Okay, please go ahead.
I think I beg to differ with what the counsel is saying. I think he needs to get your facts right, because I've seen these like old people using young ones to commit crime. Most of these compounds like Kanyama, Chuvoria, even just like these musical concerts, ask around Matero, Chuvoria, Kanyama, they're using these young ones to go and commit crime, to go and attack people. So what you're saying is actually these people are feeling like they are protected, because they know to say, once I use a young person to commit crime, so I think you need to get your facts right. And I think as law in Zambia, we need to enforce a law that to teach those young ones to say, if you commit a crime, you face the law of Zambia, and you be taught a lesson. Thank you.
Maybe you can just revise the question due to a technical difficulty.
I'm not sure if it was a question or a comment.
Yeah.
I'm not sure if it was a question or comment. But I wanted to ask this, Mr. Kapatiso, is it more you alluded to the fact that this has more of legal clarity.
Yeah.
But I feel like the proposed amendment is multifaceted. It has to do with everyday life, really, if you look at it.
Yes, it does.
On many layers that we seem to be oblivious to.
Yes,
Yeah.
yes, it does. It does, because then, like I said, interpretation, definitions affect both implementation, interpretation itself, and everything else. So whether the definition is the hands of a law enforcement agency, whether it's in the hands of the judiciary, or it's in the hands of policymakers and policy implementers, it is a tool that will help them to be able to implement or to protect the rights of children in Zambia. Without that clarity of definition that will allow them then to implement effectively, we'll have too much discretion, because you'll be hearing, no, in Kabwe, someone has been treated as a child, and so they have been removed from a marriage, or they have been removed from custody and stuff like that. But you go in Shangombo, in Nsaka, the treatment is different. So how do you harmonize our way of life in terms of treating children generally in our homes, for example? The Children's Code, which is the codified statute on laws regarding to children, highlights everything else, from adoption, from treatment from birth, from harassment, from education, everything else. So how do we ensure that when we have clarity of definition, this definition can help us address our minds to how we treat children in this country generally, across all boards, from the time they are born to the time they cross over the age of being a child into adults? How do we make sure that we are able to provide for these children? What kind of policies do we put in place? And who do those policies affect? When we say these policies to make sure that children learn ICT or get entrepreneurial skills or get some kind of business or bursaries, how do we make sure that these particular policies are getting the right group, and that the person who is on the implementing side, whether the police station in a government department, knows what to do when they have this person who produces their NRC and says, I am a child, or who is brought in, let's say this person is a person living with disability, brought in by their guardians, and their guardian says, this is a child. They have some entitlement. So how do we ensure that our treatment of children in this country complies with international human rights law?
And I think something important, I was thinking of the first caller, so that we also dispel the notion that we're removing criminal responsibility with this proposed amendment. Ideally, what this amendment or proposal aims to do is that it reframes criminal responsibility for children within the child rights-based justice system. I think over time Zambia has also evolved in terms of how we deal with children that we do interact or come into conflict with. Mleta and I both have experience of this, having worked with juveniles who come in conflict with the law within correctional facilities or prisons, as you'd say. And on top of that, what Zambia has done and what we want to see with the coherence with the definition, but as well as the policy, is we also have a national diversion policy, which is a critical part of how our juvenile justice system works in Zambia. From the first interaction with a child who, say, 12 to 14, right? Or 12 to 18, has been met with the police. How then should the police, as a first interaction point, be able to handle this child? And that's where we would want to see consistency, not just in Lusaka alone, but across law enforcement agencies and court systems across the country. Ideally, what our diversion policy also proposes is that would want to see alternative pathways or routes to criminal trials and incarceration for children that are accused of minor or non-violent offenses, but ideally assess the child's circumstances. It's a lot to do with how to handle a child in the instance that they do come in conflict with the law, or they're on the other side of being a witness, right? And one emphasis I'd like to make for the citizens to really understand, right, is when we deal with children, we must realize that it's not that we're treating them more harshly or less harshly. We're trying to ensure that we're applying more of a rights-based view, that the understanding of this child is as different from an adult. But how do we then not just, inverted commas, punish this child, but how do we reform them to become better citizens, but better adults by the time they cross over?
And which brings me to my next question. I was about to ask, this clarity that we seek, ultimately, if I'm a mother or a father listening there at home, how would this benefit my family or my children?
Well, number one, it sets in tone a very clear interpretation that will inform child protection policies, child protection laws across the country. If you're a mother, you're a father, you're a guardian, you have in your home a child, a brother, a sister, your child goes to school. Your child goes to school, and you want your child to be taken care of. They have several rights that have been listed under the Children's Code Act, and these rights should ordinarily be enjoyed by them. Clarity of definition ensures that your child is not left out on the basis of misinterpretation, of misunderstanding of who a child is, so that they are able to enjoy these particular rights. But not only at school, at church. Children are interacting with Sunday school teachers or Sabbath school teachers or anyone else. So let's say if you are in another religion, there could be some other people that attend to children when you go to these religious gatherings. How do you ensure that there is coherence in the manner and approach of treating children to make sure they are safe? Child protection, child safeguarding. In workplaces, there are workplaces that are privileged enough. I don't know at Power FM if you can come with your child and there's a room where your child can play around. If you are a mother or you are a father who has to go to work.
Food for thought.
Yeah, so there are all those, the workplace policy. If you are interacting with children, whether this child has been brought in by me, for example, I've come here for an interview and I have a child downstairs, or you have come here and your wife, your partner has left the child. So how do you treat children in your workplace? Again, how do you treat children in employment settings? Okay, we have people that drop out, unfortunately, and that's why the president is pushing for this free education to make sure that it's real. And it's real not only in Nsaka but in our villages where some of us come from. So that when these persons, for example, that have not gone through the formal education system, graduate, go to UNZA, go to Ivanhoe, go wherever and get a diploma, degree certificate, and then but have gone towards the trade skills route. And let's say this person has learned a trade under some apprentice. You have people who come, you go to a garage, you find someone who looks like 17 years old, and they're helping you change the battery and stuff like that. How are they treated in that workplace? So this definition allows us to have a very holistic approach towards how we treat our children, how we protect children's rights, and how we ensure that this crop, this generation that is coming up, is protected, is safe, and enjoys their full rights under international human rights law, but also under the Children's Code and our Constitution, as it were.
And you preempted my next question, just maybe for the sake of time. If this amendment is passed, what are the practical changes? What should we expect from a legal interpretation and policy implementation? When all is said and done, what you've explained, what are the good things that we should expect?
So ideally what you are going to expect is quicker court proceedings in terms of dealing with children. Of course, what we've seen is the delays in justice, especially when children are tried with adults in those cases. And this would then enforce the work of a lot of child rights activists and people that do ensure to protect the rights of children, that they aren't subjected to court proceedings for 24 months, right? And you're still incarcerated. Also, we'd want, ideally what you're going to also see is consistency in terms of educators that do have a direct interface with children and understanding how to protect these future leaders, as people would say, within the schooling environment, right? Also, what will we also see ideally? I think these definitions will also set the tone in terms of our labor policies and laws. On paper, we may have it brilliant and good that, we do acknowledge the rights or human rights violations of child labor, right? Mm-hmm. But what will these definitions then do in terms of enforcement? And I think, for me, I'm throwing that as food for thought.
Okay.
But I would want to see more parents, more children, more educators, more of the people in the court system, the social welfare officers, I think, participate in this process, whether they do oppose or disagree or find this progressive. I think it would be good for them to contribute to this conversation of proposed Bill number 7.
In conclusion, Ms. Kangwa, Mr. Kapatiso, how do I, as a citizen, how do parents that are listening, guardians, educators, as you alluded to, how do we stay in this conversation? How do we engage in this conversation? How do we go about doing that?
Yeah, so right now there's an open window that has been set by government to engage on the constitution amendment proposals. And these engagements, of course, we have seen Honorable Minister of Justice, Princess Kasune, going around the country meeting particular stakeholders and engaging with them on these proposals. But then in relation to the right of the child and the definition also, I would think that organizations, citizens that are concerned with children's rights should ordinarily make their submissions. They could make their written submissions through a letter to the Ministry of Justice as part of the consultation. The Ministry of Justice can be gathering these particular views and be able to add them. But also, at a particular stage, should this bill actually grace the floor of the National Assembly, there is room for submission between before a select committee. So people could still go and draft their submissions. The submission could be a one-pager. Your community group could have a one-page that just says, okay, this is our view, this is our thought on this particular provision, or any other provision at all. And so that is one way. But also engage your members of parliament. At the end of the day, the passing of this particular bill to become actually, or to gain the force of law, the effect of law, and be part of the constitution is determined by the kind of voting that members of parliament have. So if you disagree, tell your member of parliament, we disagree with this and we want you to vote with us. If you agree, tell your member of parliament, we want you to agree on these particular provisions. If you agree partly, inform your members of parliament. We agree partly with this, we're comfortable with this, but with these other provisions we're not comfortable. So we're thinking if this is going to go through, these provisions must be either be redrafted, reformed, or removed altogether, and these particular provisions must go through as they are. So let's not, I have to repeat this, this is a blank check.
Correct.
So any views to the effect that no, let's just go as it is, are lies. It's a blank check. A blank check means that we can rewrite, we can redraft, we can refine, we can remove, we can even withdraw the bill altogether. It's a blank check. So this room should, this window of consultations should be used to ensure that we indicate what kind of information, what kind of views and opinions we have on this blank check. Should it go through as it is? Should it be withdrawn? Should particular provisions go through? Should particular provisions be withdrawn? And I think that's the way that we should be thinking about this as citizens, so that we don't politicize it.
Correct.
We use this as an opportunity for discussion, for debate, not quarrels. Quarrels are trying to pull your emotions to get you confused. Debates are about an exchange of ideas, an exchange of opinions. When you say, I agree with these provisions, I can come and say, I don't agree with this because of A, B, C, D. That's what I'm calling fellow citizens to do during this particular period. You are allowed to refuse. You are allowed to tell the government withdraw it. You're also allowed to tell the government go ahead with it with all these small amendments. So that is my position, and that's how I want to close this. But also, let me just say, there is confusion around the revising or redefining or correcting the definition of the child. For those of those that are our clients, and I know that they listen to Nyanja very well. This revision sibakamba kuti manje apa bana bangazipanga milandu iliyonse la mulosiza bagwila iyayi. This revision is to make sure that there is a particular kind of process that anyone that falls within this particular age category is to be taken through. Children's Code Act nakamba kudala that diversion is a first resort. It's the first resort mwana kapanga mulandu. But bacha bamene batumfya bana kuti bapanga milandu, they are actually violating children's rights. And baja bagwiliwa bamangiwa, whether pasa bana madrugs, whether bauza bana endani mutantame muchite buhule kurodi, or endani muchite vasona so all those things, they will be arrested. But mwana akagwiliwa who is a child, who is within this definition, diversion is the first thing. And part of diversion is compared counseling, or depending on how the weight of the offense and the circumstances are, bangamupase akaenda mukoti process, bangamupase a reformatory order. And the reformatory school is school ya bana bajibana pango milandu, so ata bashite reform, they start thinking, okay, they come back to the right frame of mind, they are guided, they continue with their school even in those reformatory centers. That's what this law is about. It's not kutumfya bana kuti kazipanga ni milandu manja, bajamini batumfya bana, they will be arresting them, and even the children themselves, they'll be taken through a process. But that process will have human rights considerations, so ati mwana sachokemo traumatized kwati chalu chinamuzonda cha beyai ni kutandiza mwana so ati mwana ankale muntu wa mushe, and that's what they can become responsible citizens going ahead. Those are my closing remarks.
Awesome. Ms. Kangwa, just to close, if I'm a mother now, I'm listening and I'm sitting with my fellow mothers, I want to submit to the select committee or to my member of parliament. How do I go about doing that? Simply put, we've got a piece of paper, we've got a pen. How do we write a submission?
I think the first point of contact in terms of making these submissions is if this bill is brought to the floor of the House, your first entry point will be through Parliament. And for those that do not have the reach of Parliament, we shouldn't think everyone is privileged to be in Nsaka. You've also got the constituency offices within each constituency across Zambia, and it would be good to see more Bazimai, Wanamayo, you know what I mean, gathered together even in the markets to actually put in their submissions forth and bring in issue-based matters from the context of what they do face. If they find that, like he outrightly brought it, right? Sometimes it's junkies that are a problem, right? How do these parents see these provisions helping define and create coherence? But my last call to action, I think, is to the government. With this process, as we've always said, that process protects content, right? I think government should also be clear and open, right? If they've got email addresses or submission kind of form for the children that they do have in the homes that are educated, right? Perhaps their children can use, if it's their smartphones, or to write for those with no access to these facilities, right? To be able to make those submissions. But lastly, government should also now reconsider not just limiting the provisions to what has been provided to us, right? But perhaps now rethinking, should we also have the discussion of the Bill of Rights being incorporated in these proposed amendments?
And I certainly look forward to having that conversation on the Bill of Rights. This morning we've been discussing provision number 13, which is the revision of the definitions of child and adult. The proposed constitutional amendment seeks to revise and harmonize the definitions of a child and adult to align with the Children's Code Act and international legal instruments. A clear and unified definition will also strengthen Zambia's justice system, close legal gaps, and support the country's broader commitment to safeguarding the rights and well-being of children. We've been talking to Ms. Ruth Kangwa, who's a human rights lawyer, Mr. Muleta Kapatiso, who's also a lawyer, and also joined by the Queen of Breakfast, Fortress. Many thanks for having us this morning, for coming through this morning.
Thank you
for having us.
We certainly do appreciate. Be sure to join Voice of the People every single morning from 7:45. Good morning.
Voice of the People is a dynamic and interactive radio phoning show that gives listeners a platform to voice their opinions on current affairs, social issues, and community community concerns. With engaging discussions, expert insights, real-time audience participation. Voice of the People.